suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
And David Whiting is in the studio with you, Melbourne solicitor, and happy to take your calls. Good morning.
Good morning.
Did you have a lovely Easter?
I did. Had a very quiet time.
Excellent.
A couple of day trips, but that was it.
Very nice. 1300 222 774, and I don't get to say this very often, but there are some lines free. So take your opportunity and call us. Now, David, not that you had homework, but we have been speaking this morning about HECS debts, and a couple of people texting, and indeed I read out the text, and we had declared that HECS debts died with you. They weren't part of your estate. You beg to differ.
I do. They used to die with you. There was a HECS debt, and then it would all of a sudden nobody owed the money. It's now a debt of your estate. So if you
So
have
when did that
assets,
change?
7 or 8 years ago.
Okay.
So it's now it's your responsibility. If you have assets when you die, it will be paid for. That's where they'll get the money from.
And do they? So you have a responsibility to make a declaration if you are the executive of an estate?
Yeah, I don't know how they, in a sense, connect the dots, but there is an obligation to pay. I don't know how assiduously they follow up, but because, normally HECS debt is paid out of your salary or income every week or your pay period. So how they get to know you died, I don't know.
Okay. Interesting, though, and a correction on what we were saying earlier in the program. 1300 222 774 if you have a question for David Whiting, as Mary does in Parkville. Hi, Mary.
Good morning. Hello, David.
Hello, Mary.
I have a problem with respect to a leak that occurred in my apartment. There was a leak a year ago. It was only a small leak and I complained about it, but the building people didn't feel that it was anything to worry about because it quickly dried up and there was nothing further. But then in December last year, there was another further leak, and this time it was significantly worse, affecting a much larger area, affecting the carpet in my bedroom and hallway. So the building issues have been repaired, the pipe's been repaired and the holes in the wall have been repaired. But the issue is really about who will pay for my carpet repair. The building insurance says that they're not liable for the carpet and that I would have to...
Carpet technically constitutes contents, so it's yours, not part of the building. Yep.
Yes, well, my insurance company has agreed that they would cover the cost of the damaged areas only. But my apartment is an open plan apartment and the carpet's really continuous. And I don't feel that I should be obliged to pay for the replacement of the the carpet in my whole apartment because the leak wasn't my problem. It was a building issue. So that's what I'm asking you about, whether I can claim for the whole cost of replacement of the carpet rather than just the damaged area.
Mary, in terms of your insurance, possibly not. I mean, I would have, if it's an open plan, then I think it would be reasonable to replace the lot. I'm just minded that the last call we had last week was a lady who had a drainage issue and the insurance company refused to pay the insurance claim until someone else fixed the drainage issue. So, Mary, I think the insurance company needs to see photos of your apartment so they can see how inappropriate it would be to just, if you like, patch your carpet.
Well, they have the photos. I've provided them with it. Yep.
There is, if you look at the Insurance Council of Australia, they have a ombudsman. They have someone who will take a second look at your complaint on behalf of most insurance companies, those that don't have their own review process. And if you're ultimately not happy, you can go to VCAT. Right. If you look at it from the point of view of the owners corporation, you may have an action against the owners corporation for failing to deal with the problem the last time it came around.
Yes, that's what I think too.
But that's an action that you would probably take in the magistrates' court?
Ah.
So there is a VCAT jurisdiction for owners corporations, and if you can wait till next week, I'll see if it fits into that one. But I don't think it will be. You're alleging negligence on behalf of the owners corporation for failing to fix the problem when it occurred, and then you got hurt because it happened again.
Well, it happened again and much worse, you know.
Yeah, but it also needs to be the same problem, not just the same symptoms, but it needs to be the same cause.
Mary,
and then you have a case.
Good luck, Mary. I was going to say, David, that issue of when you make an insurance claim for something, the fixing only of the tiny bit that is damaged, even when there's an issue of continuity. I know once that we had a quote and there were weatherboards and there was flood damage that had affected some, but then once you start to replace some, you end up with a problem of others, but the insurance only covers the sum.
Well, of course, now if you're doing it, if you've got an old house, your weatherboards are imperial. Yeah, if you've got a weatherboard house, they're now all metric and they're not quite the same size, which just adds to the complexity.
And what would insurance cover that?
Well, isn't the problem is that, you know, I think weatherboards last 50 or 60 years, right? Though someone will correct me, I'm sure of that. Why would I be giving you a whole new side of a house, new for old, when 90% of the weatherboards are just fine? Sorry.
Yeah, okay.
Selfish.
Tracy in Montmorency. Hi, Tracy.
Oh, good morning. I have a problem with a roof, a leak in my roof. I had a plumber come out and he offered to fix the problem the next day, so they came back out to repair the roof. They charged me $3,000, and on the next rain it just was exactly the same.
Tracy, your first issue is you really need to find out what the problem is.
Yeah.
And I know a leaking roof isn't quite where I'd go. You can complain to the Building Commission because the plumber will be registered with them. So go back to your plumber, an email or a...
Yeah, they're not returning my
No,
email.
accept that, but maybe a text message or an email. Here's my problem, fix the problem, or I'm going to the Building Commission. And of course, given that I tried to send a lot of clients to the to VCAT, you could bring your claim there. But if you're going to do that, you've really got to go and work out what the cost of repairs is. So your next step would be complaint to the plumber. If you don't get what you want from the complaint, then go off and get a quote to get it fixed, and then talk to the Building Commission and then issue it VCAT.
Gosh, that's a long way round, isn't
Well,
it?
you're not allowed to fix your own roof.
Repairing today.
Yep.
Good luck, good luck, Tracy. Gabriel in Brunswick West. Hi, Gabriel.
Oh, hi. I have a question. I'm on a sloping block, and the back of my fence, they have a drain that catch all the water running down the car park.
Yes.
And the water goes through a pipe underground through my property to the curb. So I was wondering who is responsible for that drain if there's some problem with it, or
It will either be council or Melbourne Water.
All right.
Melbourne Water deals with the stormwater issues, but it might be a council pipe. But it's quite
Right,
possibly
okay.
if it's it'll be an easement on your property for drainage purposes. It will be whoever owns the pipe in the ground.
Have you had an issue?
Oh no, but I saw that looks like I think the pipe might be cracked because there's some watermark, some molding on top of where the pipe runs. So
then you could flag it, and it will get listed for maintenance in, I don't know, not soon, I think.
But still better probably to flag it than wait until you have a disaster on your hands. Sue in Kew. Hi, Sue.
Oh, hi. Good morning, David and Ellie. I have a rental property which I've rented out for the last 3 years and never changed the rental. It's been the same. For the last 6 months, I've incurred quite a lot of expenses with changing different parts of the kitchen and things like that, which, I obliged pretty much straight away.
Yes.
And I was just under contract only will sort of end somewhere in middle of the year or later.
So do you have a fixed term tenancy?
Yes, 1 year tenancy.
Okay. Yep.
Is there any way I can increase the rental or I cannot?
You cannot till the end of the fixed-term tenancy when you start the discussion about another fixed-term tenancy following on from that one. At that stage,
Okay.
you can review the rent.
Oh, okay, that's fine. Thank you, David.
Thank you.
Good on you, Sue. Chris in Shepparton. Hi, Chris.
Oh, good morning. I got a question regarding responsible service of alcohol. I'm a volunteer in a tourist information centre, and we have an alcohol permit to sell bottles of wine from the local wineries,
Yes.
and that's all good. But I'm just wondering whether, as volunteer, we need to have that extra one, that responsible service of alcohol,
I take it you only sell it bottled?
only bottled.
No, you don't sell corkscrews as well? Sorry, they're all screw tops now, yep. So there's no opportunity for them to consume on the premises?
No, there's not. That's stipulated in the alcohol permit we've got.
Yeah.
It says that bottles are not to be opened, consumed, etc. Yeah.
Okay. So, Chris, I'll let you know next week the absolutely precise answer to that one. I don't think so, but I'd rather get it right.
All right.
Good on you. Thanks very much.
Very good. Some homework for you, David.
I always wondered what you watched English television and what an off licence was.
Oh, yeah.
And an off licence was a bottle shop because you consume off the premises.
Ah,
Yes.
okay.
Meant nothing to me for years.
Yeah, so your gut feel would be that you wouldn't need an RSA,
You wouldn't. You would
No.
think you wouldn't, but you know,
best to be sure.
as I read somewhere today, that law is all about order, not justice. Yep.
Right, okay. Well, you go and find the order for us, David,
try.
and he will come back with the answer next week. Darcy in Kensington. Hi, Darcy.
Good morning. I'm a first-time renter. I've only just moved into a share house with 3 friends. Our house has these 2 sheds at the back, one of which has a roller door that opens up onto the rear laneway. Now, there were photos of these sheds on the listing, and neither the listing nor our rental agreement mentioned we wouldn't have access to those sheds, so we assumed we would be able to use them both. After having signed the lease, we were told we would not have access to the one with the roller door, as the owner would be using it for storage. We also suspect the owner has been accessing the shed via the rear laneway while we've been home. So my first question is, given that we were not told otherwise until after we signed the lease, are we at all entitled to use both of the sheds? And my second question is, should the owner still be required to give us 7 days notice before accessing the shed, even though they don't have to go through the house to do so?
The starting point, Darcy, is how the rental premises are defined. So if it's number 1 Bel Air Street in Kensington, then the answer would be you've got the whole of the property. If it's described as being the house at 1 Bel Air Street, then you don't have the whole of the property. So, Ian, if it's the whole of the property, there should be no access by the landlord. But what ultimately do you want to achieve?
Ideally, we would like to make use of that shed for storage, and there's even a car space in there. But even if we can't use the shed, we wouldn't like to have the owner coming in while we're home without giving us a bit of notice.
What if they just came? What if the owner just came through the roller door?
Which is what
Yeah,
Darcy's
No,
suspecting.
Yeah, but
Darcy's
there's a-
saying not coming into the house doesn't mean isn't walking down the side of the house.
Oh no, but yeah, they're coming through the roller door, but there are windows in that shed, and we can see the light on, and we'll be out in the back garden. We just
Okay.
like a little bit more privacy.
Well, you're giving some there's a couple of issues. You could talk about an adjustment to the rent.
Sure.
You could, if you're prepared to concede, or you could go back to the agent and say, sorry, we released the whole of the property. We want the space. And if you don't get a resolution, tenancy issues go to VCAT.
Okay.
Darcy, do you know what's on your lease? Is it whole of property? Is it the address?
I'm pretty sure it's whole of property. Yeah.
It will
It's just
almost inevitably be the street address.
Right,
Yes.
in which case you
Yeah.
go back to the real estate agent and
Yeah,
you say,
and
hang on, what's
I
going
rented
on?
the whole thing.
Darcy, good luck with that one. Ross in Glen Iris. Hi, Ross.
Yeah, good morning. Over my life, I've had numerous telecommunications company accounts, and I've also had numerous accounts with banks, and most of those are many years old. What is the requirement for banks to keep my data? What is the requirements for telecom organisations to keep my data? And how do I force them to remove it and delete it?
Move to Europe. You're asking not quite the right question. It's necessary for the banks and telcos and the utility companies to keep your information for as long as they need it to fulfil the functions that they perform for you. So if you no longer bank at a particular bank, there's no logical reason for the bank to retain your information. Right?
Yep.
I think that's the strict answer to your question. Banks, the next threshold would be that all of these companies are subject to audits and reviews, and it would be logical, say for income tax or anti-money laundering or compliance purposes of some kind, it would be reasonable for them to keep your data until those obligations are discharged.
Yep.
Right? And that might be 3-5 years after you finish dealing with them. So if you've got at one utility company and you then give up that contract and 3 years later there's no logical reason why they need any information about you other than your name and the account number. Don't need your date of birth, don't need any of those things.
Yes.
But it's kind of like storage is so cheap that it's easier to keep it than it is to pay someone to purge it.
And this is the whole issue with all these
Well, this was
hacks,
the opposite issue, was that
exactly.
they had data that they, for former customers, that was years and years and years old. So perhaps there ought to be a law that deals with the removal of data. But at the moment, can you compel them to remove it? And as the law it stands at the moment, no.
There you go, Ross, and I think it's a common issue. I also just want to let people know that these are reports, not confirmed, but reports from a number of journalists in Canberra around the Shadow Minister for Indigenous Australians, Julian Leeser, and these reports are that he is resigning from the front bench. As I say, only reports, not confirmed. He's called a press conference for 11 o'clock. We have been trying to get him on the program since last week. We had the announcement from Peter Dutton that the Liberal Party will be campaigning no for the Indigenous voice to Parliament. So we will wait and see what happens at 11 o'clock press conference. So stay tuned and we'll keep you up to date with that. Peter in Malvern East. Hi, Peter.
Hello. I've got a query regarding, we had a plumber come out to do a new roof on a commercial property and it was deemed non-compliant from the Victorian Building Authority, so it's gone back to the plumber's insurance. This was in 2015, actually. It's been back and forth for X number of years. Now, the problem is that I want to cover like building materials because I had Colorbond Ultra specified for the box gutters and so forth, and I was able to prove this from photographs. But I'm just wondering, how long can it stay open for negotiation? Is there an expiry limit on the time? Because it's been already 6 years now since it was first dead.
Yes, that's my problem. It's been a long time. Because the normal rule is that you need to commence proceedings within 6 years of the event or within 6 years of the time when you could reasonably have become aware of it. But from your point of view, it would be 6 years from the last acknowledgement. So if you've got an acknowledgement from the plumber, yes, it's my fault, now let's argue about how we fix the problem, that's when your 6 years starts.
No, it's gone to the insurance. So the plumber's insurance, I've been talking with them for 6 years, not the plumber. So that the plumber's insurance has acknowledged that there's a problem. They offered me a payout amount, which I didn't want to accept.
And how long ago was that, Peter?
It's been since 2017, actually. It's 2017.
Well, this is the year. So I would be taking the insurance company's agreement offer as being an acknowledgement of the problem, and that would be the last date they made the offer or confirmed the offer would be where I suggest your 6 years would start.
Okay, but do I still have time to negotiate with them after that 6 years or during that 6 years?
No, you can negotiate as long as you're alive. You probably can't enforce your claim beyond a certain point. So you can commence proceedings and then continue negotiations.
Peter, good luck. A couple of texts, David, around the RSA question.
Yes.
So bottle shop employees need to have their RSA.
Well, then logically, Chris from Shepparton Wood is a volunteer.
Yeah, and in fact, another, Richard in Baldwin, says my wife works in a retail shop selling fruit, vegetables, deli, dry foods, meat, etc., as well as bottled alcohol, and all the staff are required to complete an RSA course. And actually, when I think about it, I go to a place where a very mixed retail store like that, and there are a number of checkouts, and if you are buying alcohol, you have to use a specific checkout, which would seem to suggest possibly that's because it's manned by someone with an RSA. Yep. So, we will wait with interest.
If you think about it, it's no better serving a full bottle of wine with a screw top to someone who's overindulged.
Well, indeed.
Yes.
Absolutely. But still, your homework for next week. Let's squeeze in this call from Andrea in Oakley. Hi, Andrea.
Hi. Good morning. I was talking about live in a set of 8 units with a driveway down the middle, and in the middle of the driveway in the street is an old Telstra pit. Now, the top of it is cement and it's cracked, and they've put tar in, and so there's a hole, tar on the one side and a hole, like you could break your ankle in. So I rang the council and
It's on the footpath, is it?
No, it's in the driveway.
Inside the driveway of the units?
No, not inside, on the street side of the driveway, in the public section, but in the middle of the driveway, just as you move into the street, about half a metre from the street itself.
So, but if I was crossing in front of your property, it would be what I would consider to be the footpath.
Yes, it is. Yes,
yeah.
But I was told it's a driveway and it belongs to the units. So the council got the body corporate to send them a photo, and I wanted to know who is liable. Is it Telstra?
Yes, the pits belong to Telstra.
Yes.
So if it's a Telstra pit, it's a Telstra problem.
Right.
It's not a council problem.
But the council may liaise with Telstra.
It's not a body corporate problem.
No, it's not a body corporate issue.
Our driveway.
It's outside your property.
Yes.
And if you, as a matter of law, though, Andrea, you don't own the driveway. You have to pay to put it in, but everything from your street boundary to the road pavement belongs to the council, as does the road.
Andrea, yes, I don't think that is going to be in the purview of the owners of the block of apartments. David, thank you.
Pleasure.
We shall wait with interest for that homework next week. Nice to see you.